Hello, everyone. Welcome back from your lunch break. I will be chairing the session Energy and Shipping Dispute Resolution. This year, we decided to spice up things and add shipping as well to our discussion. The first speaker that will be presenting on the topic is Dr. Filip Saranovich. He's a dear friend and colleague at Queen Mary University of London. He's an associate professor in shipping law at the Centre for Commercial Law Studies. He's also the director of the International Shipping Law LLM program and the deputy director of International and External Engagement. Filip is an ordinary member of the European Association of Private International Law, and he was also a judicial marshal in London's High Court, shadowing the work of Mrs. Justice Gloucester when she was the judge in charge of the Commercial Court. Filip is also an external examiner for Private International Law module at King's College London, and prior to joining Queen Mary, he was a member of the Institute of Maritime Law at the University of Southampton, where he was the academic lead for executive training. Filip's work on transnational commercial injunctions has drawn the attention of the Bureau of Investigative Journalism, who interviewed him in relation to the recent articles on high-value cross-border litigation in London. And I must also praise him on his book, Freezing Injunctions in Private International Law, which was published by Cambridge University Press in October 2022. Filip will be presenting on the topic of charter party disputes and contract interpretation in shipping law. As I mentioned at the beginning during the welcoming remarks, we will aim through this panel to also give you the UK perspective. Charter party disputes is a core area of maritime practice and one where the UK continues to play a leading global role, with London's commercial court and also maritime arbitration community shaping the majority of modern jurisprudence. The UK perspective does remain central with regards to how charter party terms are interpreted and disputes resolved. And in conjunction with the global energy landscape shifts driven by LNG shipping, fuel transition obligations, and decarbonization rules that continue to evolve, charter party interpretation increasingly intersects with energy and regulatory pressures and also associated risk. So I'm delighted to give Filip the floor, who will expand more on the topic. Filip, the floor is yours.
Thank you very much, Mary, for the kind introduction, and I will now share my slides. I hope that everybody can see the slides. So I will talk about charter party disputes and contract interpretation, and we will jump to a very, very recent case coming through the English courts, which not surprisingly actually started off as a London arbitration. It started its life in arbitration. It went to the High Court in December 2024, but we now have the English Court of Appeals decision, which was actually handed down on the 28th of November this year. So we're talking about 2 weeks ago, we had the Court of Appeals decision. And as Dr. Mitzi correctly mentioned, LMAA arbitration in London and the English Commercial Court in London do get a lot of shipping disputes, particularly on charter parties, because a vast majority of standard form charter party contracts, whether amended or unamended, will provide for London arbitration in most cases. Some of these cases get appealed to the High Court, and this is how we ended up with the Skiros and the Agios Minas. So what was this case about? It was a charter party dispute. The owners of the vessel, two companies, so we have two ships here, Skiros and the Agios Minas. The owners were Skiros Maritime Corporation and Agios Minas Shipping Company. They chartered these vessels to Hapag-Lloyd. These were container vessels, but I have to explain, of course, that absolutely the same principles would apply in any other time charter party. A charter party for a period of time, whether it's a year or 2 or 6 months. Now, the charter parties had the latest date by which the vessels had to be redelivered. Sometimes we call this the final terminal date of the charter party, following usually a period of extension in the option of the charterers. Before the latest dates for redelivery, the owners of the vessel entered into MOAs, essentially agreeing to sell the vessels to MSC Shipping, and also the other vessel was going to be sold to Maersk. But the charterers, in breach of contract, there's common ground that, of course, there's a breach. The charterers redelivered the vessels back to the owners approximately 2 days in the case of the first vessel and approximately 7 days late in the case of the second vessel. So we're talking about a relatively short period of time of overrun in breach of contract. Charterers did pay higher at the agreed contractual rate, in other words, the charter party rate, during the period of the overrun. So for the period of 2 days and 7 days respectively. There was even the contract actually provided simply what the charter rate is going to be, and in the event of an extension of the charter, that the charter rate would be increased. There was no contractual provision. The contract was completely silent about what happens in the event of overrun, in the event of late redelivery, in terms of the compensation that would be payable to the owners, if any. In the overrun period, the market rate was considerably higher than the charter rate. So the market went up, and there was a significant increase in the charter rate, in the market rate of hire. The owners of the vessel started arbitration proceedings, and they were claiming the difference between the market rate and the charter hire. The owners, interestingly, and this is the main controversy in this case, the owners of the vessel did not actually suffer any actual loss. Why? Because they have already agreed to sell the vessels to MSC and to Maersk. And in the memorandum of agreement to sell the vessels, they were prohibited contractually from chartering the vessels again after the vessels were to be redelivered by the existing charterers. So if hypothetically the vessels were redelivered to the owners on time in a punctual way, the owners would not have been able to go out to the market and charter the same vessels out and get the market rate. Okay, they were unable to do that. It was simply not possible because they were contractually prohibited from chartering to somebody else. They had an obligation after the redelivery to deliver the vessels to the buyers, MSC Shipping and Maersk. Okay, so this went to arbitration under LMAA rules, which is essentially ad hoc arbitration in London, which is the most popular one by far. And the members of the tribunal found that the MOAs were accidental or peculiar to the owners. What they said was that the contracts to sell the vessel were completely collateral matters which lie outside the nexus of the breach. The MOAs for the sale of the vessels should be completely disregarded, and it doesn't matter how this affects the position. The claimant's recovery of damages is unaffected. So the arbitration tribunal relied on the so-called the doctrine res inter alios acta, collateral matters which need to be disregarded. It's nothing to do with the contract between the charterers and the owners, the charter party contracts. These are completely separate matters. We need to ignore them. So the tribunal decided to award substantial damages, which were quantified based on the market rate of hire during the period of the overrun. Okay, and the owners were successful in the arbitration. Following on from that, the charterers appealed to the commercial court. And when it came to the High Court, this was 13th of December 2024. We had a decision from Mr. Justice Bright, and Mr. Justice Bright reversed the decision of the arbitration tribunal. So the decision of the High Court was that the owners suffered no actual loss and that they were only entitled to nominal damages. Mr. Justice Bright said that the doctrine of res inter alios acta was completely irrelevant in the context of factual losses. And the key issue was the loss of the opportunity for the owners to earn higher. He looked at the counterfactual. In other words, what would have happened but for the breach of contract? If the breach had not occurred, if the vessels had been delivered on time, punctually, would the owners have suffered a loss? And the answer to that question is negative. The owners would not have suffered the loss because the vessels would go directly to the buyers pursuant to the MOAs that were agreed with MSC and Maersk. Okay, so there was no loss of a market opportunity for the owners. They have not suffered any loss, and therefore they should not get any damages. This decision of the High Court is primarily based on the so-called compensatory principle in English contract law, which tells us that the basic measure of contractual damages is to put the innocent party, or the injured party, if you like, the innocent party, so far as money can do it, in the same situation with respect to damages as if the contract had been performed. This was a principle which has long-standing application ever since 1848, so the middle of 19th century in English law. Applying that principle, there was no loss and therefore no damages should be awarded to the owners despite the charterer's breach of contract. So the lesson from the High Court was that when it comes to late redelivery, and let's of course remember that in the context of energy transactions and charter parties, the most frequent disputes arise from delays. It could be a delay at the beginning of the charter party, so late delivery by the owners, or potentially late redelivery at the end of the charter period. As far as late redelivery claims, owners must prove their loss and that they lost the opportunity to earn the market rate of hire. Now, the Court of Appeal decision, as I said at the beginning, is from 28th of November 2025. So a lot of, I think, English lawyers have barely had the time to read the decision. I wanted to talk about something very recent and something which is a fundamental point of principle in English law. So the Court of Appeal, interestingly, completely reversed the decision of the High Court, and they reached the same decision, the same outcome as the arbitration tribunal. So the Court of Appeal said that we need to place emphasis on the principle of certainty, which is one of the foundations of English contract law and commercial law. And what we need is very clear and predictable rules on the assessment of damages. That means we need to stick to the basic rule in shipping law, which is that the standard measure of damages, the default position for late redelivery, is the difference between the market rate and the charter rate for the overrun period. So in other words, damages for breach of contract, for late redelivery, do not depend on whether the owners of the vessel would have in fact entered into the market to conclude a new charter party, or the new fixture, as we say. Okay. So in terms of the approach to the assessment of damages, we have two stages. What has the innocent party lost? But we disregard any collateral dealings, such as the MOAs in this case, the sale of the vessels, which have nothing to do with the charter party. And stage two, how much, if any, of that loss can be recovered. And this is where principles of remoteness of loss come into play. In terms of the legal context, we have several principles, but the most important really here is the compensatory principle. Arguably, we could say that the Court of Appeal has undermined to some extent the compensatory principle, because according to the compensatory principle, damages should reflect the actual loss suffered, whether by the owners or in any other contract. And why is this principle important? It's important in order to avoid overcompensation, or in some cases undercompensation. But the Court of Appeal is saying, no, in this case, the owners should be awarded substantial damages based on the market rate, despite the fact that they have suffered no loss. Okay. In terms of other, of course, principles, counterfactual analysis features in a lot of English cases, and some are Supreme Court cases, and I'll come to that in a moment. And finally, causation and mitigation. Only benefits that are caused by the breach or that are causally linked to mitigation are relevant to take into account. And this is from another Supreme Court decision in the new Flamenco. This is the list of most important sort of authorities. Interestingly, and this is why what happens next will be difficult to predict. There are a number of cases, the Golden Victory and the new Flamenco have not been mentioned by the Court of Appeal in the Skiros and the Agios Minas. And this, you could say, is perhaps one of the strongest criticisms of the Court of Appeal's judgment. Also, the cases were not mentioned by the High Court, by Mr. Justice Bright. So if this case reaches the Supreme Court, then what will the Supreme Court decide? Now, in my opinion, this case will go to the Supreme Court. I think there's almost no doubt that it will reach the Supreme Court, and we will have a Supreme Court judgment in 2026. Okay. What is the suggested approach from my personal perspective? Well, first of all, the owners should always be entitled to hire during the overrun. There was, of course, no question here that the owners were at least to receive the charter rate under the Charterparty. That was common ground. But also, my second point is that the loss of market opportunity is in principle recoverable. And there are plenty of English cases which support this. However, the measure of loss needs to be assessed on a counterfactual basis, because we have the case of the Golden Victory, which is equivalent to the UK Supreme Court decision. It was a House of Lords at the time, which says that we need to take into account events which have taken place after the breach of contract. Okay. And in the Golden Victory, it was the outbreak of the Second Gulf War, which was 14 months after the date of breach, which was an early redelivery under a 7-year time charter party. The House of Lords, as I said, now the same as the Supreme Court, decided that the outbreak of the Second Gulf War, even though it happened 14 months after the breach of contract, should be taken into account in the assessment of damages. So why, in the Skiros and in the Agios Minas, are we not taking into account the sale of the vessels and the prohibition in those MOAs on chartering the vessels after the redelivery under the existing charter party? Why are we ignoring that? It's inconsistent with the Golden Victory, which was not mentioned by the Court of Appeal at all. So my view, even though I don't have a crystal ball, and it's been a roller coaster of a case, from arbitration tribunal reaching one decision overturned by the High Court, then the Court of Appeal overturning the High Court's decision, I believe that the UK Supreme Court is going to reverse the decision of the Court of Appeal and decide that the compensatory principle prevails, and that because the owners have suffered no loss, then they're not entitled to substantial damages. Now, thank you very much for, I hope that I have finished on time, and I hand over back to Dr. Mitzi.
Thank you very much, Filip. And thank you for touching upon this issue, which is a current one and hasn't still been resolved. So it would be interesting to see how all these key principles that you mentioned will be applied. The compensatory principle, the counterfactual analysis, and the causation and mitigation. And I think that this will be a groundbreaking decision, which will constitute an important precedent for future courts and tribunals to deal with it. Thank you very much. It was very enlightening, and as I said, I'm happy that we managed to spice up things this year with shipping law and specifically charter party disputes.
Thank you once again, Dr. Mitzi.
Thank you, Filip. Thanks.